Good evening. Welcome to my YouTube channel. My name is David Okon. Today I will be talking about work in the United Kingdom. If you watch this video, please watch with the rest of the videos I've made on the topic of employment in the United Kingdom. This is because what happened in the United Kingdom normally happens abroad, in the other continents of the world, in Europe, in America, and the rest of the developed world and the developing worlds. So employment as a topic and also as a concept of society is extremely important, because employment necessarily is the primary source of income in any country, including here in the United Kingdom. Work is part of employment in terms of law and policy. It is a type of employment status. I've been in this respect talking about contract of employment per se. We look at different elements in the previous videos. So watching this video, watch with the rest of the videos on this topic. Thank you so much everybody who have been helping me on this topic, in this platform, in the various elements of this program. Subscribing, watching the videos, sharing, clicking notification bell, clicking like. And for everybody who have subscribed to this channel, please, thank you so much. Those who haven't, please subscribe and support it in whatever way you can. In particular, share with family and friends. Thank you so much. Today we will be talking about illegal contracts of employment. When we talk of illegal contract of anything, let alone a contract of illegality of an employment contract, we are also saying there is something legal about that component. For example, if something is illegal, it means it is not legal. It's breaking the law. So in the United Kingdom, in terms of employment contracts, if you're in a situation where you have to work or do one thing or another within law or policy, and where you are in a situation where you are in a contractual relationship of employment, then you are going to be careful to make sure it is legal other than illegal. So today we are going to look at the illegal sample of when employment contract is not really legal. Stay tuned, continue watching. So we are going to look at fraud. A fraud involving His Majesty Revenue and Customs, which is actually the tax office in the United Kingdom. We will also look at fraud within the Department of Work and Pension. If you've been watching these videos, the videos on this channel, I have discussed elsewhere what the Department of Work and Pension is. When we talk of His Majesty Revenue and Customs, we are talking about tax office. We are also talking about Department of Work and Pension, which is responsible in part dealing with financial help given to the British people. And this is a government department I spoke about. We will be looking at it in terms of fraud or involving employment contract in the United Kingdom. We will also looking at how to advise somebody, if you are an advisor, if there is an illegal contract. We will also look at the effect of an illegal contract on every party involved. Therefore, in most cases, you could be faced in a situation where you won't be able to make a claim for any statutory or contractual right if you have an illegal contract of employment. Therefore, we are talking in terms of making claims in a relationship. We spoke in the previous videos about making claims in terms of a contract of employment. So if you sign contract of employment, you're also thinking of making claims. But under these circumstances, if the contract is actually illegal, it means it doesn't exist. It means there is an illegality involving that relationship. That relationship is legal between employer and employee, as compared and perhaps also contrasted with a type of legal relationship which is a statutory. I've discussed the difference between contractual and statutory legal relationship in terms of employment contract. In terms of employment obligations and also benefits and rights, and we are beginning to see here that if there is an illegality, perhaps also involving fraud and other elements of illegality, that will invalidate any contract, in which case if you are in a situation to make claim within your right, you will without more have no right, or in terms of law, in terms of contract. This is because your contract of employment will have been null and void due by virtue of illegality. Stay tuned, continue watching. Let us also note that in terms of employment, statutory and contractual right in terms of claim, if there is an illegal contract, impact on statutory as well as contractual right, which in most cases, which means in some situation, you may be able to have some right, some capacity, some leeway to make an employment claim, even if your contract is illegal. And therefore, the only claim you might be able to make is if there is a discrimination claim. Remember, discrimination claim will not preclude whether or not a contract is illegal. This is the information. So illegal contracts of employment would include, for example, contracts designed to defraud the tax office, HM, revenue and customs, and the Department of Work and Pension by not paying tax or national insurance. National insurance is relevant because if you pay your national insurance, it may, as often it does in the United Kingdom, contribute to your whether or not you get a state pension, and if you do so, getting state pension accurately or otherwise, if you get state pension, impact on your other types of pension in terms of work pension, for example. That's why we're talking about the Department of Work and Pension in terms of whether, in terms of a situation where the contract of employment is illegal. We are talking about how it would impact on the Department of Work and Pension, because it actually affects a situation of national insurance contribution, whether you pay it accurately or not. National insurance, like I said, will relate to your state pension and the level of that pension, whether you get more or less or you don't get it at all. Stay tuned, continue watching. So also, let us look at a situation where so another situation where employment contract might be illegal is if the contract is actually designed mainly for immoral or illegal acts, for example, procuring prostitutes or unauthorized selling of collateral drugs. These are examples where you may be in a situation of illegality in relation to employment contracts. Therefore, you would also find a situation where contracts are prohibited by law. For example, work in breach of immigration rules. If it is actually in breach of immigration rule in the UK, if you need to have the right to work in the United Kingdom. So if you do not have right to work in the United Kingdom, there are employers who may recruit employees whether or not they are have checked their immigration statuses. Therefore, any contract designed when a person is not really having a right to work in the United Kingdom risks being illegal, and illegality of employment contract. Therefore, when there is a claim, it will be difficult or perhaps impossible to make a claim, or you lose your right of employment in that sense. So we also are looking at contracts which were lawful when made but are now illegally performed. The way the law is actually performed also affect whether or not it is legal. Its illegality and legality may relate to the law being accurate in one way or the other, but there may be problem with carrying out the way it is performed in terms of proper procedure or the rules of performing such a contract may have been done inappropriately, in which case you would be in a situation where you face illegality in terms of employment rights, employment law, therefore undermining your employment rights in a situation when you want to claim in relation to those rights. So in this case, a party who knowingly participated in that illegal performance cannot enforce such a contract. And an example of San Ling Chinese Medicine Center versus Liam Wei. This is a case Wei G 2010. So there is a requirement of knowledge under these circumstances. If you knowingly, if you knew it was illegal, so these are very fine information which you look for when you are looking at legal text and also at policy information, because if you didn't know, probably it's a different case. But if there's evidence showing you knew there was the legality, you are reasonably expected to have known, then there is a problem under those situations. So a tribunal will have to decide whether or not a party knowingly participated in the illegal performance. So there would be an investigation trying to establish this information. Stay tuned, continue watching. So we have also a situation where, if a contract tries to take away a worker's statutory rights, remember we have talked about statutory rights, which is very fundamental in terms of rights. Sometimes employers try to substitute statutory rights by setting up contractual rights, which is a more inferior law in terms of giving right to employee. Some employer may try to set a type of contract which undermines statutory right of an employee. Statutory right is actually is obligatory. The employers are supposed to actually perform this, but this material is saying it is not an illegal contract per se, but the clauses which try to do this cannot be enforced. So these clauses are null and void and in law, because it is trying to actually to take away a worker's statutory rights in that sense. So we are looking also at defrauding HM Revenue and Customs, or the Department for Work and Pension, as a form of specificity in terms of a situation involving illegality of employment law, employment contract per se. So an employee may have an illegal contract of employment if they get all or part of their wages paid cash in hand, and the tax and national insurance contributions are not paid on the wages when they should have been, and the employee actually knew rather than ought to have known they were being paid in this way to avoid paying tax or national insurance contributions, and they participated in it. So the contract of employment will be legal if only one of the parties is involved in the fraud. For example, if where the employee receives payments which are their responsibility to declare. And also an example of this might be where an employee receives a basic wage from the employer from which deductions are made, but also receive fringe benefits which they did not declare. Stay tuned, continue watching. So another situation is where the employee believes that the deductions are being made by the employer. If the employee is unaware that tax is not being paid by the employer, HM Revenue and Customs will usually pursue the employer for any tax due. If national insurance contributions have not been paid by the employer, the Department of Work and Pension may credit the employee's national insurance record. Stay tuned. So you can find out more about incomplete contributions of our national insurance. So the Employment Appeal Tribunal has held that for the contract to be illegal, there must be some form of misrepresentation, some attempt to conceal the true facts in Enfield and Technical Services Limited and Payne and Grace versus BBF Components Limited 2006. These are cases. So the fact that the parties are wrongly labeled their working relationship have entered into an agreement which has the effect of defrauding HM Revenue and Customs is not sufficient to make the contract illegal. A contract won't be illegal if an employee is involved in an act of fraud or dishonesty against the employer, for example, if they make false expenses claims. So, how does illegal contract impact on an employee or somebody else or an employer? So, if there is an illegal contract, neither the employer nor the employee will be able to enforce any statutory or contractual right. For example, an employee cannot claim under dismissal, unfair dismissal, or redundancy payment, or a right of notice. This is because such claims rely on the contract of employment. However, an employee may still be able to make a claim of discrimination, as discrimination claims do not rely on a contract of employment existing, or seek to enforce a discrimination claim. In one case, the Court of Appeal ruled that a constraint of sex discrimination is not based on the contract of employment. It decided that the employee, although aware of the illegal contract, in this situation, the employee was construed as not colluding with the employer and had been discriminated against, as shown in Hall and Woodstool Hall Leisure Limited 2000 case. So time spent working under an illegal contract of employment won't count towards continuity of employment. This means that if an employee, as in the past, had some illegality in their contract with their employer, their continuity of employment may have been broken. Any period of employment before the period of illegality does not count. So any period of employment before the period of illegality does not count in any calculation of how long the employee has worked for the employer. Usually, a legal contract will affect the way you handle a dispute or a situation, a problem arising for an employee or somebody affected in the situation. So if an employee seems to have an illegal contract, they should be referred to an experienced employment advisor, because this is almost, you could say, it's a specialist area. This is because the case may be thrown out of a tribunal or court if the employee may risk prosecution or deportation and costs. So stay tuned, continue watching. There are situations when a business has been transferred from one business owner to another in terms of employment contract, in terms of work in the United Kingdom. Remember, like I said, a problem of a law or policy in the United Kingdom where people are trying to deal with one problem or another when you are in the United Kingdom, when you are in Europe or in another country. It is important to compare the situation in the United Kingdom and also the situation in your country. I keep repeating this point. Subscribe to my YouTube channel if you haven't subscribed. If you have subscribed, I'm so grateful. And also click like and click notification bell. If you watch the video, share with family and friends. Thank you so much. So we are looking at a situation in the United Kingdom in terms of employment law, where when a business has been transferred from one business owner to another, and how this may affect the status of contract. So when a transfer of undertakings, protection of employment regulation, we will see in terms of a regulation set by the government to protect employment, out as TUPE, protect people. So we are looking at TUPE, something called TUPE, which stands for Transfer of Undertakings, Protection of Employment Regulations, is law. When TUPE does protect people, and how does TUPE protect people in a situation, and which is TUPE, as I repeat, is Transfer of Undertakings, Protection of Employment Regulations, and how it does the protecting, and what is an undertaking in terms of definition, what it means to be in a situation, to how can people provide they are protected, and how can they provide proof that they are protected by TUPE, by TUPE, who is protected by TUPE, and also which transfers which transfers are covered by TUPE, relevant transfers. An example of transfers likely to be covered by TUPE and labor-only businesses, where the only transfer is of employee, and also which transfers are not covered by TUPE, contracting out or outsourcing of services, or changes in terms and conditions in TUPE, and insolvency, occupational pension scheme, dismissal, qualifying period for claiming unfair dismissal, and also employer liability information, employer's duty to consult and information employees about a transfer, objecting to working for the new employer after the transfer, and so on and so forth. So let us try to define what TUPE is: transfer of undertakings, protection of employment regulations, which is a type of law here in the UK in a situation where there is a transfer of business from one operator to the next. When a business is transferred from one employer to another, the Transfer of Undertakings Protection of Employment Regulation 2006 may give employment protection to people employed by the business. These regulations are commonly known as TUPE regulations. Transfers which occurred before the 6th of April 2006 are covered by the Transfer of Undertakings Protection of Employment Regulations 1981. The TUPE regulations were made to implement the European Acquired Rights Directive number 77/187. This means that when courts in the United Kingdom considers claims under TUPE, they must also take into account the European directive and any decisions made by the European Court of Justice (ECJ) on the directive. This area of employment law is recognized as complex. This is because both the United Kingdom courts and the ECJ, European Court of Justice, have made decisions which seem contradictory. There are also some questions which the courts have not dealt with, and so there are no definite answers to them. It is likely that you would be in a situation where you need help from a specialist employment advisor in a possible TUPE case. Although the law is complex, advisors should remember that the intention behind the European Acquired Rights Directive is to protect people who work for businesses that are taken over by other employers. This means that if it seems that you are in a situation where you could gain from TUPE, an appropriate claim should be made. If necessary, tribunals should be reminded that the intention of the European Directive is to protect people's rights. Stay tuned, continue watching. Thank you so much for your help in watching this material, and also leaving a comment below, clicking like, subscribing to buy this material. Stay tuned. So let us look at how TUPE protects people. TUPE protects people in the following ways. Employment is automatically transferred with full continuity from the former employer transferor to the new employer transferee. So the time you are actually in a situation where you have to work for the former employer, this period counts toward the length of employment with the new employer, as if there has been no change. This means, for example, that if you are in a situation where you are an employee and is eventually made redundant, you can also count all the time they have worked with the old employer and with the new employer when calculating how much redundancy pay you are entitled to. So employment also with the new employer must be on the same terms and conditions as with the former employer. For example, for if you are in a situation of transferal, if you are being transferred, you should receive the same pay and have the same conditions to sick pay and holidays as you have had if you had before the transfer. And also the new employer takes on all the liabilities of the former employer under the contract of employment, including negligence and breach of statutory duty. An employer's liability for an accident at work is also transferred to the new employer, as in the benefit of the former employer's insurance policy, as can be seen. Any criminal liabilities do not transfer to the new employer and stay the responsibility of the former employer. Also, any dismissal because of the transfer, either before or after the transfer, is automatically unfair unless it is for an economic, technical, or organizational ET or change in the workforce, any recognized trade union, or if there is no union, the employee representatives of affected people must be informed and consulted about the transfer. Stay tuned, continue watching. So what is an undertaking? An undertaking can be an entire business or a discrete part of the business. For example, if a supermarket is taken over by a new employer, a new owner, that would be a transfer of undertaking and all the staff would be protected under TUB. However, the cafe within the supermarket might be taken over by a new owner while the rest of the supermarket remains with the former owner. If the cafe is a discrete part of the supermarket business, that is, if it is a separate economic entity, then it can also be an undertaking. The TUB rules would apply to the staff employed in the cafe when it transfers. So how can people prove they are protected by TUB? If you are in a situation where you wish to use TUB either to protect your terms and conditions of employment or to claim unfair dismissal, there will usually be two stages to the argument. You will also need to establish that you are an employee of the undertaking. You will have to show that the transfer of undertaking in question was a relevant transfer and that you should therefore be protected. Let us look at who is protected by TUB. Workers and TUB. TUB will protect you in a situation if you are an employee of the undertaking. An employment tribunal has decided this includes people who are workers but don't meet the normal definition of employee. If you are not sure, check your employment status. Stay tuned, continue watching. If you find yourself in a situation where you are a worker who aren't an employee, this means you will be protected by TUB, but you still can't make a claim for unfair dismissal or statutory redundancy payments. Other tribunals don't have to follow the decisions, but there are good legal arguments why they might. You can check the reasons for the decision, Dewhurst and Revised Catch Limited 2019. This is the case. So you could be a worker who isn't an employee and who needs to rely on TUB. If this is the situation, get specialist help from an expert team. So TUB protects people who either were employed in the undertaking in the UK immediately before the transfer. It is relevant if the undertaking is then transferred out of the UK or even out of the European Union. If they work in different sectors of the businesses, and only one section is on undertaking which transfers, a tribunal would have to decide whether TUB applied to them. The tribunal would take into account, for example, how long they spent working in each section, the comparative value of the work they do in each section, and which section of the business pays them. And also, they would have transferred with the undertaking if they are not being unfairly dismissed beforehand because of the transfer. So we look at also independent contractors, that is self-employed people working in business. who are not transferred because they are not employees of the work of the undertaking. So also, which transfers are covered by TUPE are relevant transfers. What is the relevant transfers, therefore? TUPE may apply where an undertaking transfers from one owner to another. This is called a relevant transfer. Relevant transfer is defined as either the transfer of an economic entity which retains its identity, or when a service provision change takes place. For example, where a contractor takes on a contract to provide a service for an employer. So the two definitions are not exclusive, and many transfers will meet both definitions. In most cases, when an undertaking is transferred, TUPE will apply because the factors in the paragraphs above will be met. There are a few important exceptions where transfers are not covered by TUPE. Often, it will be quite straightforward to judge when a transfer has taken place or is about to take place, provided one of the exceptions does not apply. When an undertaking is sold as an ongoing concern, and the purchaser intends to carry on the original purpose of the undertaking, and it is clear that this transfer is covered by TUPE. Stay tuned, continue watching. This is the case even where the purchaser intends to incorporate the purchase undertaking into their existing one, or when two businesses merge to form a third. The principal factor which determine what is a relevant transfer were decided by a particular case. The tribunal or a court will look at all the following factors both before and after the transfer to determine whether the new undertaking has kept its identity as an economic entity. So the factors are the type of undertaking, the transfer of tangible assets such as building and stock, the value of intangible assets such as goodwill, whether the majority of staff are taken over by the new employer, whether the customers are of the undertaking transfer to the new undertaking, the degree of similarity between the activities of the old and the new undertakings, the length of the time between the old undertaking finishing and the new undertaking starting. It is important for both transfer and transferee, transferor and the transferee employers to claim that TUPE does not apply to what may actually be a TUPE transfer. Advisors or expert or professional need to be cautious in accepting such assertion from employers without examining the factors that indicate whether or not it is likely that a TUPE transfer has in fact occurred. A failure to do so may lead to clients being denied important protection and rights. Clients should be referred to specialist employment for help if the advisor is in any doubt as to whether there has been a TUPE transfer. So, what is an economic entity? In order for TUPE to apply, the undertaking which transfers must keep its identity as a stable and identifiable economic entity. This means that it has a definite business purpose which the transferor, the former owner, is selling and which the transferee, the new owner, is intending to continue. It should be possible to identify the same undertaking both before and after the transfer. For example, if the cafe of a supermarket is the undertaking which is transferring, it should remain a cafe after the transfer to the new owner. If the new owner changes its use when it transfers, so it becomes, for example, a dry cleaners, then TUPE may not apply. If the transferee is only intending to continue the business for a short period, or for a finite period to finish a certain task, the business may not be judged to be stable, and TUBE will therefore not apply. Stay tuned, continue watching. There is a list of which transfers are not covered by TUBE. Case law has established that an economic entity may be not necessarily limited to performing one specific work contract structured and autonomous, but may not have significant assets, either tangible such as machinery or intangible such as a customer goodwill. In some cases, labor intensive only with no significant assets apart from the staff, for example, a cleaning operations, an organized grouping of wage earners specifically and permanently assigned to a common task, for example, security staff for the Olympic Games or other major supporting events. You can also look at economic entities to include non-commercial undertakings such as voluntary organizations, charities, National Health Service Trust, and local education services. It can also cover transfers between subsidiary companies of the same business group, administrative reorganizations, or the transfer of administrative duties between public administrative bodies is not covered by TUBE. There is a list of transfers which are not covered by TUBE. Stay tuned, continue watching. Does the new owner intend to carry on the business? It is important to consider whether the purchaser intends to continue trading. Continue watching, stay tuned. If they have bought some physical assets of a business, for example, a building or some equipment, with the intention of selling or scrapping them or using them for a very different purpose than the original business, then TUBE probably will not apply. However, if there has been a small change or development in the business purpose, TUBE may apply. For example, if a baker shop has been sold to a particular purchaser who develops the shop into a continental bakers and patisserie, TUBE will probably apply. This is because the broad purpose of the business and therefore its economic entity to sell bread and cakes remains the same. The purchaser may also have kept the same customer base and may have paid for customers' goodwill in the purchase price of the business. Stay tuned, continue watching. So look at service provision and changes. Service provision changes concern situations where a service performed by the main employer is awarded to a contractor. This is commonly called outsourcing or contracting out, or a service contract is assigned to a new contractor, often as a result of retendering, or a service contract is brought in-house by the main employer, insourcing or contracting in. We are looking at common examples including office cleaning, workplace catering, security guarding of premises, refuse collection, and machinery maintenance. There may also be examples where a company has a dedicated team to work for a particular client. In order for there to be a service provision change, there must be an organized grouping of employees which has as its principal purpose the carrying out of the activities concerned on behalf of the principal employer prior to the service provision change. An organized grouping of the employees can include a single employee, for example, as solitary cleaner of small business premises. where there is a team of employees established to perform services on behalf of another, the client, and that client decides to switch to a different contractor, a relevant transfer may occur provided other criteria are satisfied. For example, a particular case involved a law firm which successfully bid for a major client contract. The firm inherited employees who had previously worked on that client's behalf at the previous firm, along with liabilities for those employees. An employee will transfer over under a service provision change if they spend sufficient time on the client contract and is therefore assigned to the activities transferred. In order for there to be a service provision change, the activities carried out on after the service provision change should be fundamentally the same as those carried out before the transfer. Thank you so much. Stay tuned. Let us look at examples of transfers likely to be covered by TUBE. Transfers of businesses which are likely to be covered by TUBE will be transfers by sale, transfers by operation of law, transfers by some other disposition. Let us look at transfers by sale. Transfers by sale happen when a business is sold to another owner. This is fairly straightforward and could include the sale of a business to another employer, to a single employee, to a group of employees, as in a management buyout, or to a workers' cooperative. Conditionally, stay tuned. We also look at conditional or deferred sales arrangements where the sale is conditional upon certain factors, are also covered by TUBE, even though the absolute ownership of the undertaking has not changed. And stay tuned, continue watching. So let us look at transfer of a business or operation, transfer by operation of law. The transfer of a business by operation of law happens by an automatic legal process. These include the automatic succession of a business from a deceased sole trader to their personal representative, the automatic reversion to a landlord of an expired, forfeited, or surrendered lease. Wherever a lease on property is granted, terminated, surrendered, or assigned, and as a result of that legal transaction, a business changes hands, there will be a TUBE transfer. Other cases which have been found to be TUBE transfers include one where a tenant's lease on a tavern was forfeited and the running of the business automatically reverted to the former owner of the property who became the employer of the staff working there. The frustration of the contractual agreement, such as a franchise, the undertaking will transfer back to the from the franchisor. A business transfer resulting from a court order as well. In a particular case, the Employment Appeal Tribunal decided that the appointment of a trustee in bankruptcy could be a transfer by operation of the law. Stay tuned, continue watching. Thank you so much. So we are looking at transfer of operations by some other disposition. A transfer by some other disposition happens not as a result of the business being sold, or because a transfer was needed for legal reasons, but for some other reason, TUB has been held to apply in the following types of transfers. The switching of a public grant from one organization to another to provide a distinct service, the gift of a business from one person to another, the transfer between two subsidiaries of the same group of companies, stay tuned, the contracting out of services, the continued operation of a business that had ceased to be a legal entity when the company was struck off the company's register. So the taking over by a brewery of the running of an insolvent social club for a couple of months until it was sold, when the owner of a subcontracting company and his staff were taken on as employees of the contracting company, where licenses or leases are involved. For example, in one case, the Employment Appeal Tribunal decided that there was a transfer of undertaking when the company granted a license for one of its parking operations to another employer, even though the equipment used to carry out the work remained the property of the original company and remained on their premises, because an identifiable economic unit had been transferred, namely the parking operations. This was still a relevant transfer. So the transfer of a vehicle dealership from one motor company to another is another example. The granting of an informal license to a company using machinery in order to complete a contracted out industry process. TUB and labor-only business, where the only transfer is of employee. Stay tuned, continue watching. So the transfer of labor-only service provision businesses has been one of the most contested and controversial areas under TUB. The ECJ and the UK courts have allowed labor-only businesses to be covered by the Acquired Rights Directive ARD and TUB. This means that, for example, cleaning contracts were covered by TUB even when the purchaser did not buy cleaning equipment from the seller. In a significant case, the ECJ decided that where a sole cleaner was transferred from one employer to another, TUB did not apply. In a subsequent case, however, the ECJ held that labor-only businesses may not necessarily be covered by TUB. In this case, the ECJ said that in certain labor-intensive industry, a group of workers engaged on a permanent basis in a joint activity could constitute an economic entity. In order for TUB to apply, however, the mere continuation of the activity alone would not count to a relevant transfer. It will not amount to a relevant transfer. There also has to be a transfer of tangible or intangible assets, or the taking over of the majority of the workforce. The UK tribunals and courts seem less willing to follow the approach of the ECJ, and there have been a number of cases where TUB has been held to apply in circumstances where the ECJ may arguably have reached a different conclusion. So as we look at the transfer of employees, the transfer of employees remains very relevant to whether or not TUB applies. If no employees are taken on, this may lead to a tribunal or court to the conclusion that there is no transfer. However, if no employees were taken on because the transferee employer was deliberately lying, trying to avoid tube registration regulations, then tube is highly likely to apply. If you are in a situation to advise an employee who has lost a job because of a business transfer that look as though it could have been a labor only transfer, you should advise the employee that tube may apply and that they may make a claim for both unfair dismissal and redundancy. So a client in this position should be referred as soon as possible for a specialist employment advisor. Stay tuned, continue watching. So we're looking at which transfers are not covered by tube. Tube does not apply in the following circumstances. Share-only transfers. If a business changes ownership because of acquisition of shares only, there is no transfer of the business, and so tube does not apply. This is because the employer, the company, remains the same legal entity. Assets only transfer, where there is a transfer of assets only, assets meaning material goods such as property or equipment. However, if only assets and goodwill are transferred, but no employee, the Court of Appeal has said that tribunals must consider why no employees have transferred. If it is because the new employer is trying to avoid tube, then that is a strong indication that tube applies, especially if the business is labor intensive. New employers cannot avoid tube merely by not taking on any employees from the former employer. An employee in this situation should be referred immediately to a specialist help. Insolvency asset transfer, when the former employer has been declared insolvent and the purpose of the transfer is the realization and the distribution of assets of the business on behalf of its creditors. However, the tube rules do apply if an insolvent business is transferred and the purpose of the transfer is to enable the business to continue trading. There are other important changes with regard to insolvent businesses. Public administration. There is no relevant transfer where there is a transfer of administrative functions between public administrative authorities. Most transfers within central and local government are not covered by tube, but staff are protected by other broadly equivalent provisions. However, transfer from public administrative authority to provide private bodies, usually known as contracting out, are covered by tube. No identifiable employees. There is no relevant transfer where there is no identifiable group of employees providing a particular service or activity. Guidance from the Department for Business, Innovation and Skill (BIS) gives the example of a courier firm that provides courier services to various customers on an ad hoc basis. Because it would be difficult to identify which employees were assigned to a particular service, there would not be a relevant transfer if the courier service transferred to a new employer. One of short duration contracts. There is no relevant transfer where there is a contract for a single activity or event and there is no intention to have an ongoing relationship with the contractor. For example, if an employee is taken on to organize one-off conference and the business they work for transfers to a new employer partway through their contract, this would not be a tube transfer in their case. However, if they were part of a conference team who regularly organize conferences for customers of the business, and the business transferred, this would be a tube transfer, a tube that apply to service provision changes. So in looking at supply of goods, there is no relevant transfer where there is an arrangement between a contractor and an employer, which is wholly or mainly for the supply of goods for use by the employer. For example, if the contractor supplies sandwiches and drinks to the employer's canteen for selling on to its own employees, that would not normally be an arrangement covered by tube. If, however, the contractor enters into a contract with the employer to provide canteen catering services on the employer's premises, and the employer then transfers the contract to another contractor, for example, as part of a retendering exercise, then this would normally be covered by tube. Stay tuned, continue watching. Contracting out or outsourcing of services. Please note also the information about service changes and outsourcing above before reading this section. This can be an issue when services are contracted from a public service employer to a private service employer. It may also be an issue when there is a subsequent contracting out after this first transfer. These are known as second generation transfers. So, for example, school cleaning and refuse collection is contracted out from a local authority to a private cleaning company, and all the staff transfer to the private company under tube rules provide under tube rules. Then the private company contracts out the refuse collection part of its business to another private company. These will normally constitute another tube transfer. In this example, the employees working in the refuse collection undertaking would transfer to the new employer, while those employed in the school cleaning undertaking remain with the existing employer. Example where tube has been found to apply in contracting out of services include the contracting out of cleaning services by a bank where only one employee did the cleaning, the transfer of hospital cleaning services from one contractor to another, a teacher employed to teach prisoners who was previously employed by the local education authority. She was transferred under tube rules when the education authority contracted out its prison teaching contract to a local college. So, second generation transfers. Second generation transfers happen when a business transfers a second time. It commonly occurs when a public sector business has been contracted out to a private sector employer, and it's then transferred to another private sector employer. For example, Company X transferred its cleaning services to Company A in 2002, so the employees of that part of the business transfer. In 2004, Company X puts out to tender its cleaning contract, which is won by Company B. There is then a second generation transfer or employees from Company A to Company B. You can look in fair detail about public sector transfers, employment law. Stay tuned, continue watching. Stay tuned, continue watching. Let us look at changes in terms and conditions and TUPE. The new employer cannot make changes to the terms and conditions of employment simply because there has been a transfer, unless the only reason for the change is an economic, technical, or organizational ETO reason, and titling changes in the workforce, provided the employer and employee agree that variation or the existing terms of the contract permit that variation. If the employer and the employee do not agree the ET or variation, the normal rules on variation of contract will apply, but it will not be a TUPE-related contract change if the ET or reason is made out, and so could give rise to a claim of unfair constructive dismissal, but not automatic unfair constructive dismissal. You can find out a bit more about normal rules on when an employer can vary a contract. So the question therefore rises about the point at which the employer can seek to vary the terms of the employee's contracts after a TUPE transfer has occurred, provided that a link can be established between the transfer and the variation to the contract. There is no absolute time limit. Stay tuned and continue watching. In one case, nearly 2 years had elapsed between the transfer and the variation, but the tribunal still held that the variation was connected to the transfer. However, the longer the period between the transfer and the variation, the more difficult it may be to establish that the underlying reason for the variation was the transfer. In England, Wales, and Scotland, from the 31st of January 2024, if a contract contains provision of collective agreements, rights under such collective agreements which are agreed and come into force after the transfer do not transfer if the new employer was not a party to the collective bargaining for them. If you comment below and let me know your thought. Stay tuned, continue watching. So the Court of Appeal has decided that the principle that changes the contract made as a result of a TUPE transfer would void does not apply to changes which are made to the benefit of the employee. Only changes which are to the transferred employee's detriment are void. In this case, an employee worked for an employer where the retiring age was 60. He was TUPE transferred to a new employer where the retiring age was 65. So the Court of Appeal said that through the transfer he had obtained a new right, that of being able to work up to the age of 65 if he so wished. We are looking at variation of terms and conditions agreed under a collective agreement. In England, Wales, and Scotland, from the 31st January 2024, terms and conditions which were agreed under a collective agreement can be varied when more than 1 year has passed since the transfer, provided that overall the employee's contract is no less favorable than it was when immediately before the variation. This means that the employer could seek to agree variations to terms agreed under a collective agreement which may be less favorable to an employee, so long as the employee gets some other more favorable term, so that overall they are in no less favorable a position than before the variation. If they are in a less favorable position as a result of the variation, the purported variation will be void. Any variation must comply with the normal rules on variation of contract. More about normal rules on when an employer can vary a contract. Contractual retirement age and TUPE. The Court of Appeal decided that a normal retirement age is not the same as a contractual retirement age, and does not therefore transfer when there is a tube transfer. Continue watching, stay tuned. So if the employee has a retirement age specified in their contract, then this contractual term will transfer in a tube transfer. However, employers cannot force an employee to retire without good reason. It's direct age discrimination. It can be read more about workers' rights in retirement. Can tube give additional rights? The Court of Appeal has held that tube does not create rights which did not exist prior to transfer. In this case, the claimant had worked for a company since 1999. In 2004, she moved to the dependency company, CIS, under a tube transfer. CIS had a more generous redundancy package for people who had joined it before 2002. When the claimant was made redundant in 2005, she argued that a tube meant that she has continuity of employment with the CIS dating back to 1999. She should be given the more generous redundancy package. The Employment Tribunal agreed, but the Employment Appeal Tribunal and the Court of Appeal did not. The fact that tube gave her continuity of employment did not mean that she was entitled to a benefit from a scheme which did not exist at her previous employment. Tube does not create rights to which a transferred employee was not entitled prior to the transfer. Can the employee challenge a change to the terms and conditions? The tube regulations describe circumstances when contract variations may arise and whether or not such variations are valid. Changes which are not valid cannot be enforced and can be challenged by the employer. Stay tuned, continue watching. It can be challenged by employee where the sole or principal reason for the variation is the transfer itself. Such variations are invalid and can therefore be challenged. Variations which are not for an economic, technical, or organizational reason entailing changes in the workforce or reason. Such variations are invalid and can be therefore challenged. Variations which are for an or reason, these may be valid changes, therefore challenges may not be available. Variations which are nothing to do with the transfer, the regulations have no bearing on these as they are nothing to do with the transfer, and the usual rules about variation of a contract of employment apply. You can look more about variation of to employment contracts where the pre-transfer contract permitted such variation. These are valid. Also, an employee whose terms and conditions are being changed is likely to need advice from a specialist employment advisor. So let us look at variation simply because of the transfer. Where an employer changes terms and conditions simply because of the transfer and there are no other circumstances linked to the decision to change terms, that change has come about because of the transfer itself. For example, the transferee employer may want to change the terms of the transferring staff so they are the same as those of their existing staff. Stay tuned, continue watching. So let us look at transfer for ET or variation. We'll look at variation for an ET or reason. So where the reason for the change is because of a knock-on effect of the transfer, such as the requirement to retrain staff to use different machinery owned by the transferee, the employee can challenge such a change unless the employer can show that there is an economic, technical, or organizational reason for it entailing changes in the workforce. An employer may try to argue that the changes to the terms and conditions of employees are so great that they amount to an economic, technical, or organization ET or reasons. An employer also dismissing employees and offering new contracts. Let's have a look at this. Although the aim of TUBE is to protect the terms and conditions of employees, transferee employers frequently wish to vary the terms of the transferring employees. It is difficult for the transferee employer to vary contracts lawfully and not risk employees bringing claims in the tribunal and courts. Although variation of contracts because of a tube transfer are prohibited, the dismissal of the employees and the offering of new contracts on the new terms and conditions is not prohibited under TUBE. Where the new employer wishes to vary the contracts of transferring employees but cannot argue that this is for a valid ETO reason, they may decide to terminate the contract and issue new contracts. Although this is not expressly prohibited under TUBE, the dismissals are very likely to be unfair. An employee will then have to choose whether or not to accept the new contract. If they don't, they may be able to make a claim for unfair dismissal. If, however, they accept the new contract, that is, they start working under the new contract for the new employer, they may have substantially mitigated mitigated their losses under the new terms and conditions. Stay tuned, continue watching. Thank you so much. Subscribe to this channel if you like the video. If you don't like the video, share the video with family and friends. Thank you so much. So an employee in this situation must be referred for a specialist advice about whether it is worthwhile for them to claim unfair dismissal. A transferee employer who dismisses employees in order to achieve continuity, contractually binding harmonized terms and conditions of employment between all of their employees risks being liable for compensation for unfair dismissal and other claims such as unauthorized deduction from wages owing to reduced pay. The transferee employer cannot argue the ET or defense in such circumstances. Stay tuned, continue watching. The employee may need more information about dismissal and TUBE, where employees are no longer needed to do the work and would, if there were no transfer, be properly regarded as redundant, then the ET or defense ought to apply. In such circumstances, the employees may be eligible for redundancy pay provided they have worked for the employer for long enough. Insolvency and variation of contracts. From the 6th of May of April 2006, there are important differences in the rules regarding the variation of contracts where the undertaking is solvent. Stay tuned, continue watching. Let us look at variation to contract terms where the employees has not been dismissed. If the new employer has not terminated the existing contract but has offered a new contract on whose terms and conditions after a transfer, the employee may try to challenge the worst terms and conditions in one or more of the following ways. They may argue that the variation is void under TUBE or object to the change in writing, continue to work at the protest and bring a claim to a tribunal, for example, for unauthorized deductions from wages if the new contract is paying them less than the old contract. They should raise a grievance before bringing a claim to the tribunal if there is time to do so within the time limit for making a tribunal claim. Let us look. You can look more about raising a grievance in England, Wales, and Scotland, more about raising a grievance in Northern Ireland, about an action which occurred on or after the 3rd of April, more about raising a grievance in Northern Ireland, about an action which occurred for the 3rd of April 2011. Stay tuned, continue watching. We can look at also at claim claiming constructive unfair dismissal as well. Stay tuned, continue watching. So someone will have to work for the business for the qualifying period before they can make this claim, adding together time spent with the former employer and the new employer. They should raise a grievance before bringing a claim to the tribunal if there is a time to do so within the time limit for working for making a tribunal claim. So you can look at how to raising a grievance in England and Wales and so on and so forth. Thank you so much. Continue watching. Stay tuned. So this is a very complex area of employment law. If you are in any doubt as to how to advise an employee, you should refer them to a specialist employment advisor. So if an employee's wages have been cut, where business has been transferred, and the new employer reduces an employee's wages, for example, by cutting wage rates or bonuses, or imposing unpaid overtime, an employee who wants to object should do so in writing. The employee may then make a claim to an employment tribunal under Section 13 Employment Rights Act 1996 that there have been unauthorized deduction from their wages. They should raise a grievance before bringing a claim to the tribunal if there is time to do so within the time limit for making a tribunal claim. There is a 3-month time limit for on making a claim for deduction from wages to tribunal. But as the 3 months starts to run out from the last deduction underpayment that has been made, an employee who is still employed and therefore still being paid will be unlikely to be out of time. So if the employer dismisses an employee because they have objected to an unauthorized deduction from their wages, then the client can claim unfair dismissal irrespective of how long they have worked for either the transferor or the transferee employer. This is because they will be claiming that the dismissal was caused by them asserting a statutory right. So look at variation to contractual terms where the employee has been dismissed. Employees who have been dismissed where there is a tube transfer and then taken back on taken on by the new employer under words contract under words terms and conditions may consider claiming against both the former employer and the new employer in the employment tribunal for automatic unfair dismissal, provided they have worked for the business for the qualifying period, and redundancy provided they have worked for 2 years in the case of statutory redundancy pay if they have not received any redundancy pay due. They may also be entitled to contractual redundancy pay and or any other claims due, such as holiday pay or owing to them. So the employer should have used a dismissal procedure when dismissing the employee. If the employer has not followed a dismissal procedure without good reason, a tribunal may take this into account when deciding on compensation. If an employee is out of time for claiming for an unauthorized deduction from wages, or if the new employer has changed the contract so that the employee has a substantial loss, they may sue for the breach of contract in the county court. Let us look at TUBE and insolvency. From the 6th of April 2006, the TUBE regulations introduced important changes to the transfer of insolvency businesses. The changes concern the liability for debts to employees and special rules regarding the variation of employees' contracts. These rules only apply where the insolvent business is transferred as a going concern. They do not apply to insolvencies that are pursued with a view to liquidating assets, whether by creditors or members winding up the business. Also, they do not apply unless insolvency proceedings are being started before the transfer. So let's look at liability for debts and insolvent company. The regulation limits the extent to which the debts of the insolvent company pass on to the new employer. The following payments will not pass on to the new employer. Instead, these debts will fall to be paid by the government through the National Insurance Fund. These include statutory redundancy payments, basic awards for unfair dismissal, arrears of wages, holiday pay, and pay in lieu of notice. So any payments owing to employees which are not listed above will not be met by the government and will become the responsibility of the new employer. Advisors will therefore need to determine which debts will be met by the National Insurance Fund and which may pass on to the new employer. In some cases, an employee may need to claim to a tribunal for both the debts covered by the National Insurance Fund and the other debts transferring to the new employer. Thank you so much for watching. We are going to meet next time to continue on the topic where we left. Subscribe to my YouTube channel if you haven't subscribed. If you watch this video, watch it with the rest of the videos, and also share with family and friends. Leave a comment below. Let me know what you think. See you in the next one. Thank you. Bye bye.